Jurisdiction. Def and classification. Jurisdiction, in law, is the authority of a court to hear and determine cases. It's the power of the court to settle the matters. It is derived from the ancient legal maxim, ubi jus ibi remedium, which means that where there is a right there is a remedy. The judicial forum must have jurisdiction to deal with the matter. Hence, the jurisdiction commonly rests where the crime is committed. Territorial. Territorial jurisdiction refers to jurisdiction over cases arising in or involving persons residing within a defined territory. It can also be the territory over which a government, one of its courts, or one of its subdivisions has jurisdiction under this. Territorial or local jurisdiction. The geographical limits of a court's authority are clearly delineated and specified. It cannot exercise authority beyond that geographical, territorial limit. Subject matter. Subject matter jurisdiction is the requirement that a given court have power to hear the specific kind of claim that is brought to that court. While litigating parties may waive personal jurisdiction, they cannot waive subject matter jurisdiction. Pecuniary. Pecuniary means related to capital. It deals with the question of whether the court is competent to try the case of the financial value. Original. Original jurisdiction refers to the court's authority to take notice of cases that could be decided in these courts in the first instance itself. Unlike appellate jurisdiction wherein courts review the previously decided matter, here the cases are heard afresh. Appellate. Appellate jurisdiction refers to the court's authority to review or rehearsal the cases that have been already decided in the lower courts. In the circumstances, both the High Court and Supreme Court have the appellate jurisdiction to take the subjects that are brought in the form of appeals. Classifications of law. Norm. Rule or principle. Norms. Derived from norma, meaning standards. It tells us what we ought to do. Rules are a directive that attaches specific consequences to a specific set of facts. A rule is more specific than a norm principle. It is a general policy of law. A principle guides and has flexible application, unlike a rule which binds. As per Dworkin, a rule applies in an all or nothing fashion, unlike a principle. Rationale behind rule. Islamic law. Illah, operative cause, plus hikmah, wisdom, background justification for rule. Hikmah is the explanation for the rule. Further reading. pg 194 to 195, Intro to Law, Nyazi. Basis of classifications. Rules on a similar subject matter can be classified in categories, e.g. contract, marriage, divorce, equity, etc. In Islam, rules are termed as zabita, and grouping as bab. Classification of law into common law and equity. Background. The common law was historically administered in the king's courts, and equity developed as a separate system of mainly discretionary remedies administered by the Lord Chancellor, often as a way of ameliorating the injustice done by inflexible rules of the common law. Equitable concepts such as trusts are now generally dealt with as part of the business of the Chancery Division in the High Court. But since the Judicature Acts of 1873–75, when the systems of law and equity were fused, they have no longer been treated as separate jurisdictions, and both legal and equitable remedies can be provided in all the courts. Historical diff B. W. suit in equity and law. 1. Absence of jury. 2. Flexible approach. 3. Scope of review on appeal. 4. Kinds of redress available. 5. Equity gave rise to new areas of law, e.g. trusts. Substantive law and procedural law. Substantive law and procedural law are terms used to describe and distinguish two different types of law. Substantive law establishes the rights and obligations that govern people and organizations. It includes all laws of general and specific applicability. Procedural law establishes the legal rules by which substantive law is created, applied and enforced, particularly in a court of law. Substantive law is a statutory law that deals with the legal relationship between people or the people and the state. Therefore, substantive law defines the rights and duties of the people, but procedural law lays down the rules with the help of which they are enforced.